It is time again for Legal Talk right here on eRadio with Hahn and Hahn Attorneys. And joining us today is Associate Attorney Merilynn Plessis to talk about something very interesting, something you're probably doing right now, posting on social media. A big hello to you, Merilynn. How's it going?
Hi, Jan. It's going very well. Thank you. How's it going that side?
Very good. Thank you. Very, very good. Nice and cool. Real winter weather.
Yes.
So, yes. What's it like your side? Also nice and cool.
Very cool, but hot on the legal side.
Hot on the legal side. I like that. Yeah, it's always hot on the legal side, eh? Always.
Yes, always.
So today we're talking about social media. It's something most of us are on. I mean, if you know how to use a computer or a phone, you're probably on social media. You've got a Facebook profile or an Instagram profile. And it's so easy nowadays to say what you want. And that can get you into a lot of trouble. That brings me to our first question for today, Merilynn. Can a social media post get me into trouble?
Thank you, Jan. Yes. So whether we like it or not, and the pun intended, social media has become merged in our everyday living with little to no escape from being involved therein. And to answer your question, yes. If it's defamatory in nature, you may be looking at a danger of civil action and a criminal action.
Yeah, so you can't just go and say what you want, even if it's, about a celebrity or a politician or a comment on that. You can get into big trouble. But what is defamation really? How does it connect to social media posts?
So, defamation can be defined as the wrongful and intentional publication of defamatory words or conduct pertaining to a person. In our new constitutional order, reputation forms part of the concept of human dignity, which is fundamental to our constitutional values. So in order to succeed in a claim of defamation, there'll be 4 requirements to prove. These are wrongfulness, intention, publication, and the defamatory words or conduct about the person. Once the last of these requirements are established, the publication is presumed to be both wrongful and intentional. So what this means is that should a defamation claim be taken to court, the person who is being taken to court will have to prove the opposite. The onus, as we like to say, will not rest on the person who has instituted action, but the one defending it. This moves away from our general rule in law that the person who alleges must also prove. So to avoid triggering the presumption and consequently liability for defamation, the defendant must raise a defense that rebuts either the requirement of wrongfulness or intention. So the test for defamation is objective. That is, whether in the opinion of a reasonable person, the words have the tendency to undermine, subvert, or impair a person's good name, reputation, or esteem in the community. So the test asks how a reasonable person of ordinary intelligence would have understood the publication. A recent court case between Hahn versus Zuma has highlighted that a reasonable person also takes into account not only what the words say, but also what they imply. Then defamation is also a crime. Apart from the civil remedies of an interdict or a claim for monetary compensation, it may also give rise to a criminal prosecution. So I pause here to mention we'll explore on the new developments in law touching herein later. The main link between social media and defamation lies primarily in the requirement of publication. So since defamation is aimed at the protection of a person's reputation, which is the public estimation or worth or value of a person, as opposed to the individual's personal sense or self-worth or self-esteem, it is an essential element to prove that defamatory statement be published or made known to some person or persons other than the persons being defamed. So without publication, the esteem in which a person is held by others cannot be diminished.
Merilynn, that's very interesting. I want to ask you, is defamation limited to speech or print?
No, interestingly, it's not. This means that publication of photos, sketches, cartoons, and even caricatures can be equally defamatory. So platforms such as Instagram and Snapchat come to mind.
Yeah.
However, it doesn't stop there. Once publication is established, the plaintiff who brings the action must prove that the publication is attributable to the defendant, and that is the one that's made the defamatory statement. It will be attributed to him if he or she could reasonably have expected that an outsider would take cognizance of the defamation. And then also very interesting to note when considering to reshare a post is that a person who repeats, confirms, or draws attention to a defamatory statement will also be regarded as being publishing the statements. So that person will also be in hot water.
Oh, so just by sharing it, you can also get into trouble because it kind of means
by sharing.
It kind of means you agree.
Yes.
Yeah. Sure.
And even liking, I would say even liking, because you haven't done anything to disassociate yourself with that statement.
I always wonder, when you laugh at a post and somebody gets into trouble, if they go into those emojis and see who is laughing at the post, and then those people can also get into trouble. I wonder, I've wondered before, can I get into trouble for that?
Well, that's a whole legal topic that we need to explore in the future.
It's complicated.
There's some new developments on the emojis, actually.
Oh, okay. Is it good?
Not for you if you are using the wrong emoji. Remember what I've said to you.
Yeah.
So what I've mentioned now previously is that it's not just the words that you say, but also what you're implying on your posts. So in your emojis, if you're implying something, then you might be in hot water too.
Well, can you give us a few examples of defamatory statements?
Sure. Okay. So we've got some cases that illustrate broad categories of statements which have been held to be defamatory or capable of defamatory meaning. These include statements which affects moral character, imputing, for example, dishonesty or commission of a crime or association with criminals. Let's say unethical or unprincipled behavior or grave misconduct or immorality. And then statements reflecting on office, profession or occupation. Obviously, statements reflecting on political character. Statements imputing financial embarrassment, and that's also very important to companies, or statements imputing characteristics which lower the person to whom they refer the estimation of right-thinking members of society generally.
Okay, and then who can be defamed and who cannot?
Okay, so since defamation is a wrong done to the reputation of a person, every natural person whose reputation is unlawfully injured will, in principle, have a course of action. This means people like you and me. But the law doesn't stop there. Companies are also considered persons in our law, which take the form of a juristic person. So this means a trading corporation may sue for defamation if the defamatory statement was calculated to injure its business reputation or to affect the trade or business which it was formed to carry on. Interestingly, who cannot be defamed is the state, and therefore they cannot be taken to court. The principle doesn't only apply, so it doesn't only apply to the central government, which is our head government, but also provinces, our 9 provinces, municipalities, and actually all juristic persons which are part of the governance of the country. That is, we call organs of state.
And, saying state, can I include Eskom in that as well?
So Eskom at the moment, we don't know if that's a state-owned entity at the moment, but that's not an organ of a state. Organ of state and a state-owned entity is different. So they'll reserve and I'll caution you.
Okay, so I can't say Eskom is absolutely useless, but everybody's writing that.
You cannot say that.
Everybody's saying it.
You cannot say that.
They're going to have to sue a lot of people. Yeah, they're going to have to sue a lot of people.
I don't think Eskom has enough
money.
I think they're too busy with other battles to fight the defamation battle.
Exactly. Yeah, you're right. Okay, so the next question, what defenses can be used against a claim of defamation?
Okay, so let's say you're sitting on the other side of the seat and you're the one that made the statement. So you'll recall when I provided the definition, I said that in defamation proceedings, the publication of a defamatory statement, when it's proved or admitted, there's two presumptions that arise, namely that the publication was wrongful and that the defendant acted with intent. Therefore, so when you're defending a claim, you'd have to establish either some lawful justification or excuse, or the absence of intent. So there is quite a few, but I've limited my examples to 3 quite interesting examples. The first would be self-defense. So let's say you are defending your character, your reputation or conduct. It will be lawful. The immunity, although on that, would be provisional. So let's say the publication was done with intent and improper motive, it would be excluded. And then the second is what we call in rixa. So there's authority that that the proposition that a defamatory statement published in rixa, which means in the course of a quarrel or a fight, will not found action for defamation. That is, you would succeed if it wasn't premeditated and that is planned, or that it was done in the heat of the moment. But then also, the statement should not be persisted in after the fight, so it's kind of that heat of the moment. But then at saying that, there's also no consensus between our courts on the finalization of that. And then the last is making a statement made as a joke. So liability will be excluded by proof that a person or the persons to whom it was published understood the statement as a joke, which simply caused amusement. Once again, we need to remember that it's an objective test. It's what others perceived it to be. So it would depend on how they perceive it. But the mere fact that a statement raised a laugh does also not mean that it's not defamatory. It will remain defamatory or insulting or degrading to the butt of the joke, if I can say.
Yeah. And it's also a good excuse, to say, hey, I was just joking.
Exactly.
That can be a way out for a lot of people, but they actually meant it, so you'll never know, really.
Yes. It's also a difficult one.
That is a difficult one. Merilynn, what are the remedies that the law offers the victims of defamation?
Okay, so we are looking at 3 remedies. The first would be to obtain an interdict, and that would only be when a publication of a statement is threatened. So the person about to be defamed is not obliged to wait for the act to occur and sue for compensation afterwards. The person can go to court for an interdict to prevent the publication, typically by way of an urgent application. Should a person then choose this route, the applicant must show that the respondent is about to publish or to continue the publication of the statement, that the publication will be unlawful, and that the applicant will be irreparably injured if the interdict is not granted. Obviously, a respondent who admits an intention to publish a statement, which is on the face of it defamatory but sets up a defense excluding lawfulness, must state sufficient particulars to enable the court to evaluate the defense, as it's got a wide discretion in considering whether or not the interim interdict should be granted. The second claim is through instituting civil proceedings in a court where the statement has already been made.
Okay, Merilynn, and also the next question I want to ask you, what can be claimed in such an action brought against someone for defamation?
Okay, so the answers is damages, and I'll explain. So, seeing as though the primary object of defamation proceedings is to enable the person defamed to vindicate his or her character by way of compensation for damage done to his or her good name, it would be done in the form of general damages. So 1, you'd be sitting with a claim for general damages, and 2, also special damages. But these claims, they'll succeed if the legal requirements are satisfied. So what this means is a person who is successful in such an action will be awarded with an order claiming some form of money from the person making the defamatory statement. And then, as I said earlier, we'd go into the latest legal developments on the criminal side. In December 2021, the Cybercrimes Act was heralded into law. And this act makes provision for inter alia malicious communications. So the act criminalizes what it calls malicious communications. In particular, these are data messages that either, one, incite violence or damage the property. An example are these riots that we experienced last year, and then any messages that threaten people with violence or damage to property, and then any messages that contain an intimate image. So the disgruntled ex-boyfriend or girlfriend cannot cyberbully the other with an intimate image anymore.
Yeah, thank goodness for that.
Yes. So, and then in closing on the defamation, the last point I'd like to be, kind of highlight is the terms and conditions to some of the social media platforms. And that just brings us full circle to what I've said. So I'll just share a few. On Facebook, you may not bully, intimidate, or harass any user. You may not post content that is hate speech, threatening, or pornographic, incites violence, or contains nudity, or graphic or gratuitous violence. You may not use Facebook to do anything unlawful, misleading, malicious, or discriminatory, and you may not post content or take any action on Facebook that infringes or violates someone else's rights, which I've already pointed out is a constitutional right. And then on Twitter, you may not incite or engage in the targeted abuse of or harassment of others. And then on Instagram, you may even be removed from any activity that abuses, harasses, threatens, impersonates, or intimidates others.
But nobody reads the terms and conditions anyway, and then they're so surprised why they end up in Facebook jail.
Yes, and then, and now the difficulty is, that there's actually just, all sides are covered now. So the legal sides are covered, and your agreement is covered. So there's no way out.
Yeah, exactly. Oh man, this is very, very interesting. Okay, let's move on now from defamation to harassment. What is the definition of harassment?
Okay, so first I'd like to say the social media harassment has now been on the rise. There's many victims suffering at the hands of unknown harassers, hiding facelessly behind an electronic facade from where they do their dirty work, often changing their online persona as and when necessary to continue harassing their victims to evade identification. And given that the harasser is often unidentifiable, victims are unsure as to what they can do to stop the offending action. So the good news is that victims are not without recourse. In 2013, the Protection from Harassment Act came into operation. So this act seeks to assist victims of harassment from known and unknown harassers, and I'll explain. So the Act's definition of harassment is very wide, and it includes, among other things, directly or indirectly engaging in conduct that causes harm or inspires a reasonable belief that harm may be caused to the victim, or even a related person through engaging in verbal, electronic, or any other communication, irrespective of whether or not a conversation actually ensues. It also includes the sending or the delivering or the causing the delivering of letters, telegrams, packages, faxes, emails, and any other objects to the victim or even a related person, or conduct which amounts to sexual harassment. So this definition will include cyberbullying and online harassment.
And then, Merilynn, I also want to ask you, what can a victim do if they believe that they are now being harassed?
Okay, so the Act provides for the issuing of a protection order and the enforcement thereof by our magistrates' court in what is a relatively informal and cost-effective process to follow, and which can be launched by any person by completing prescribed forms with the clerk of the magistrates' court. So after the forms are filled, the matter will be placed before a magistrate who can then issue a protection order. where the perpetrator is unknown, and this is, I think I'd like to highlight this, and is using social media and electronic platforms to conduct harassment, the Act empowers the magistrate court to issue a directive to electronic communication service providers, so that's your Vodacom, your MTN, your Cell C, to provide the full details as per their records of the perpetrator using the account or email address through which the harassing action is being conducted. The Act also empowers the court to order the police to conduct an investigation into harassment in order to identify the perpetrator. And then lastly, the Act further requires that the electronic communication service providers and the police to report back to the court after having been ordered to provide the information and conducting the investigation.
Okay, and then one more question. Who can apply for a protection order?
So obviously, that is why we are here. A legal representative can assist a person, and in the alternative, a person may just represent themselves in the application. As I've said, it is cost effective and it's quite an informal process.
So for our listeners dealing with this at the moment, whether it's an ex or a disgruntled ex-employee or whatever, how can we get in touch with you, Merilynn, to give us some assistance?
So we also use social media platforms. Anyone can visit either our website at Hahn Law or LinkedIn or Facebook, and we'll be available there to assist.
Okay, so that's how we contact you, and then you can help us and tell us what we can do and what we can't do. But you answered a lot of questions today, but I still have some questions for you, but we'll leave that for next time. There's a lot lot to talk about when it comes to social media and online stuff. It's actually a never-ending pool of topics, actually.
and yes, and I mean, obviously one of the hottest topics at the moment is the papaya.
Yeah.
And that goes into with your social media, because I mean your privacy rights are also being invaded.
Yeah, you're right. You're right. Merilynn, thank you so much. Associate Attorney at Hahn & Hahn Attorneys. It was nice talking to you today. I hope we'll chat again soon, and next time we'll give you some more questions there on social media and what you can do online and what you can't do. And that was very insightful today. Big thanks to you.
Thank you. Thank you for having me.